Welcome back to Hannity. So Emperor Obama believes that he has absolute power when it comes to immigration, but a federal judge yesterday struck a blow to the president when he wrote that parts of his amnesty actions are in fact unconstitutional. Now, Judge Arthur J. Schwab from the Western District of Pennsylvania issued a scathing memo dismantling the White House's legal reasoning and argued that President Obama tried to steal Congress's lawmaking powers, an action my next guest has been warning us about. Joining us now is George Washington University law professor Jonathan Turley. And for the record, you agree with a lot of the president's policies. You voted for the president, right?
That's correct.
Yeah. And I think your words when you said he's bringing us to a constitutional tipping point have resonated now in light of this. This is what the judge said yesterday. The court holds that the executive action is unconstitutional because it violates the separation of powers and the take care clause of the Constitution. A scathing rebuke, in my opinion, from the legal side. What do you say?
Well, it certainly is scathing. You know, there is an issue whether the judge reached a bit too far from the case at hand. You know, this really wasn't a challenge, direct challenge to the immigration action taken by the president. But it is scathing, and the judge is touching on many complaints that have been raised in other lawsuits that do directly challenge these actions. What's a serious question here is the president's decision to go it alone, not just in this area, but other areas. We don't have a license to go it alone in the United States. The scope of this type of action is legislative in nature. It's huge. It affects millions. But more importantly, it requires both the federal and state governments to spend a great deal of money to support something that didn't go through the legislative branch. And what people miss, and I think what this judge is trying to establish, is that that process of legislation is the very touchstone of our system. It's what brings stability to our system. We have to agree. We have to compromise through legislation. When a president does it unilaterally, it takes that whole system offline, and that can be a dangerous thing. Why
do you use the words constitutional tipping point? And you said that even before this executive action on immigration. Why do you say, because that's harsh, severe language.
Well, I think we are at a tipping point. This trend didn't start with President Obama. We've seen this trend growing over the years. The center of gravity in our system, our three-branch system, is moving, and we're creating this all-powerful presidency, this type of uber presidency. The really key to the Madisonian system is that nobody has enough power to go it alone. That was the genius of James Madison. But what we're seeing is the rise of a new model of presidency. And I believe that the supporters of President Obama will rue the day when they stayed silent in the face of this type of concentration of power. This is the very danger that the Constitution was designed to prevent, the concentration of power in one person's hands or one branch.
Yeah, you know, my mother used to always warn me, you'll rue the day, so I haven't heard that in a while. What recourse does the Republican Party have? I know John Boehner brought you in on a lawsuit. What would you advise those that want to keep this balance, the separation of powers? What recourse do they have?
Well, there are a number of things that can be done, but the most direct happen to be challenges that are popping up around the country, not just the House lawsuit, but in a variety of different areas. The important thing is for people to understand that what we're seeing is a change in our system. This is very serious. It is nothing to do with President Obama's policies. Some of us may agree with those. It's how he's doing it, not what he's doing. And that should unite everyone. You know, we just had a report come out today of a huge number of what's called memoranda that the president has issued, including
more than any other president. Yeah.
That's right. And so we're losing the focus of our system. We're becoming even less formal. You know, we've gone from presidential orders to memoranda, and we're de-evolving in that sense, away from what the framers wanted.
Well, the president, you know, has been very blunt. If you don't do what I want, I'll act alone, unilaterally. The legislative branch has the power of the purse. I don't think they have used it wisely to this point, but with the new majority, they should be able to use that, in my opinion, to stop a lot of what the president wants to do. Agree, disagree?
Well, they can, but this president has shown there's limits to the power of the purse. Many of the changes that he ordered in areas like health care were ordered by him unilaterally. He did not get appropriations or approval. The Libyan war was funded entirely out of discretionary funds. And so the power of the purse has its own limits in light of this emerging new presidency that we're seeing. That's what makes this so dangerous. We're dealing with what is becoming a different type of system. And what the framers believed the separation of powers would accomplish was to protect liberty. It wasn't there to protect the three branches. It was there to protect individual liberty from the concentration of power. And that's what we're seeing, Sean.
All right, Jonathan Turley, George Washington University law professor, thank you for being with us.